polls and had a high incidence of sausage consumption. It doesn't prove that the people eating too many sausages produced that result. In other words, that there's no correlation. Could you comment on that? Because if that falls apart, you don't have much of a case.
Oh, we think there's still a strong case, but certainly when we come to the court hearing and we begin to examine this, we fully expect that there will be challenges to evidence. But we have some confidence that when the courts look at this and evaluate in the face of substantial evidence of fraud, right? That's clear. In the case of substantial evidence of fraud, we think the courts, on balance, will look at some of this and say, you know, this is very serious, and it may well have affected the outcome in ridings.
They accept that in Peggy's case there was fraud. That's not 18 votes.
But we'll seek records to be filed in court from the robocalling companies. Who have you called? When did you call them? What was the nature of the message? And so it may well be that absent academic evidence, that there would still be a substantial case if we can demonstrate that there's a number of calls in a riding.
Discovery. You're going to get a lot of evidence that way.
Yeah, I mean, Anke Kessler is the academic at Simon Fraser, and that's the study you're referring to. And I'm sure her methodology will be challenged by those who don't want our application to succeed. And experts disagree about issues with respect to which they express opinion. One of the interesting things about Ms. Kessler's work is that we didn't commission her to do it. It was something out there as a draft paper in the academic arena, and we asked her if we might use it in support of our application. It's in the process of being peer reviewed. So we'll see what other evidence comes forward, and ultimately it'll be up to the judge to determine whether or not the methodology that she's put forward, looks very rigorous and thorough to me, is reliable. And there may be competing views, and I suspect that she'll be questioned and cross-examined on her evidence, and we will certainly have questions of any evidence that might be forthcoming from this point on that another party may retain a consultant to offer.
On that point of getting call records, I mean, would you be in the course of this be able to subpoena records from, say, this company Rack 9 or from RMG? I mean, what kind of powers will you have in the course of the litigation to obtain the kind of evidence you would need to support an allegation of wider spread fraud in these ridings?
Yeah, under the federal court rules, we can require the attendance of individuals to answer questions for cross-examination and to produce evidence and documents and material. We'll have to, if those notices are contested, then we'll have to persuade a judge that the evidence we're seeking is relevant to the case before the court. But yes, there's certainly in the rules the opportunity to engage in the kind of investigative inquiry, discovery process that we see Elections Canada engaged in in a criminal context.
Are you doing that? I mean, are you going to try and get the records from the
We're going to have to establish how much of this activity took place in the particular ridings with respect to which applications have been brought. So we'll need to know whether there were 7,700 calls or 3,000 or however many there were, whether they were live calls, whether they were automated calls, and we'll have to get phone records, and we'll have to ultimately determine how many calls from the numbers that our applicants may have noted or that we'll be able to discover were made on those occasions into the riding.
Ignorance of the system, but you talk about two tracks. One of the tracks is the Elections Canada track. The other is your track before the federal court. You will pursue your track. Elections Canada is going to find either malfeasance or not. Is it up to Elections Canada? Could they then make a determination about whether results in ridings should be struck down, or does that always have to go through the federal court? I'm just wondering if they could get to a point and decide that results shouldn't be struck down, and then that could sort of scoop your process, if you will.
It is only the only authority with respect to the validity of an election result is the court, not Elections Canada. And interestingly, or at least I find it interesting, Elections Canada can't bring an application before the court. Its remedy is limited to prosecuting those who may have been guilty of wrongdoing. Only an elector or a candidate can bring an application under Section 524.
All right. Thank you very much.